Welcome, curious minds, to another deep dive. Okay, let's unpack this. Today we're getting into the fundamental principles of criminal law. I mean, the very rules that shape our society and really define justice. You've shared some incredibly insightful sources with us and our mission. Well, it's to extract every important nugget, connect the dots, and make these complex legal concepts clear and, accessible. Think of us as your guides through this intricate landscape, helping you quickly get well informed on this essential topic.
Absolutely. And what's truly fascinating here, I think, is how these principles aren't just like abstract ideas floating around. They're the actual architectural blueprints of our legal system. They affect everything from our daily interactions right up to the highest courts. They form this sort of invisible scaffolding that keeps society structured and hopefully fair. So we'll explore the foundational definitions, the big philosophical debates that have shaped legal thinking for, well, centuries. And the practical applications, too, how laws get made, applied, interpreted. Which really brings up a core question, doesn't it? How do we, as a society, actually decide what's right and wrong? And then how do we enforce those decisions in a way that genuinely reflects justice?
Good question. Let's start right at the beginning then.
Yeah.
What is criminal law? Fundamentally, our sources define it as, okay, that branch of public substantive law which defines crimes, treats of their nature, and provides for their punishment. So break that down a bit. Public substantive law, that's about the rules affecting the public interest, rights, duties, offenses, society's official rule book, basically.
Exactly right. Imagine society as this huge, complex organism, right? Public substantive law. That's its skeleton, its vital organs. It's the core framework telling us our rights, our obligations. And crucially, it marks the boundaries. It clearly says these actions over here, they're so detrimental to the public good, we're calling them crimes. It's not just about stopping bad things from happening, but clearly drawing that line, defined what's acceptable and what's not for the good of everyone.
Okay, and it goes deeper than just naming the crime. It treats of their nature. What does that really involve?
That's where the real understanding comes in. It digs into the why and the how, the essential elements that make up a specific crime, the context surrounding it, and very often the intent behind the action. Think of it like understanding the anatomy of a crime, not just sticking a label on it, like a doctor diagnosing an illness. They don't just say you're sick, they explain what the illness is, why it happened, what parts are affected. This detail allows for a much more precise and fair application of the law.
And then the consequences. If someone breaks these rules, criminal law provides for their punishment.
That's the enforcement part, yes. Once something's defined as a crime, the law has to spell out what happens next. And this serves multiple purposes, doesn't it? Maintaining order, deterring others, sometimes rehabilitation. It's the system's tangible response when those social boundaries are crossed. It ensures the rules actually have teeth.
Got it. Now let's talk about the main framework for this in the Philippines, the Revised Penal Code, or RPC, Act No. 3815. It officially kicked in on January 1st, 1932. But this wasn't created in a vacuum, was it?
Oh, definitely not. The RPC wasn't just invented overnight. It was largely based on the Spanish Penal Code of 1870, so you're looking at a direct legal lineage there. It really shows how legal systems often reflect history, colonial influences. It's like inheriting a legal identity. And what's really interesting is Article 366, it acted like a bridge. Even after the new RPC started, provisions of the old Spanish Code could still apply to felonies committed before 1932, as long as the time limit for prosecution, what lawyers call prescription, hadn't run out. It smoothed the transition between legal eras.
That's fascinating, that overlap. So apart from the huge Spanish influence, what other streams fed into the RPC?
Well, it was quite a mix. Obviously, the Spanish Code was the main blueprint, but it also pulled in ideas from Del Pan's Correctional Code of 1916 that was a more localized proposal. And crucially, rulings from the Philippine Supreme Court before 1932 were factored in, like practical case studies guiding the framers. Then there was influence from American penal laws during that period, especially for big things like treason, sedition, libel. It brought in some, let's say, modern legal thinking. And the RPC isn't frozen in time either. It's a living document. Congress keeps amending it. Even presidential powers have shaped it. Executive orders during emergencies or transitional periods have tweaked specific articles. It shows how law needs to be agile sometimes.
Right, adapting to circumstances. Okay, so we have the code, but why do we punish people? It's not straightforward, is it? There are different schools of thought here.
Not simple at all. And yes, different philosophies, like looking through different lenses. Let's start with the oldest one. The classical or juristic theory, its core idea. Man is basically a moral creature. We have absolute free will. We choose between good and evil. So this theory puts more weight on the result of the crime The harm done, rather than the person who did it. The act is key.
It's like chess, maybe. Every player knows the rules, chooses their moves freely. A bad move is a deliberate choice, and the penalty reflects that move's impact.
That's a great analogy. Under this view, criminal liability stems directly from that free will. And the penalty. It's seen as retribution, balancing the scales, making amends for the harm. And generally speaking, our revised penal code leans heavily on this classical theory. But then you shift the lens and you get the positivist theory. This one sees human nature a bit differently, more complexly. It suggests that sometimes people are pushed into wrongdoing by strange and morbid phenomena, external forces, internal compulsions, things that constrain their choices, sometimes against their own will.
So sticking with analogies. If the classical view is a sailor with total control of their boat, the positivist view sees that sometimes strong winds, currents, maybe social or economic pressures, or even faulty rigging can push the boat off course, even if the sailor didn't intend it.
Exactly. So liability here isn't just about free will. It's about the sum of social and economic factors influencing the person. And the penalty isn't purely retribution. It's aimed at prevention and correction, stopping future crimes, maybe helping the individual change. You see this influence in things like indeterminate sentences, where there's flexibility for rehabilitation, or how the law looks at mitigating circumstances where outside factors played a role. Then there's a middle ground. The eclectic or mixed theory. Pretty much what it sounds like. It combines elements of both. The idea is for crimes rooted in social or economic issues, maybe lean towards the positivist approach. Focus on rehab, root causes, be more compassionate. But for really serious, heinous crimes, apply the classical theory. Focus on the gravity of the act, on retribution.
Like tailoring the response. Some crimes get a more customized approach considering the circumstances. Others get a standard, firm response because the act itself is just so bad.
Precisely. It acknowledges not all crimes spring from the same motivations. And finally, we have the utilitarian or protective theory. This one puts society's well-being front and center. Its main goal for punishment is simply protecting society from actual and potential wrongdoers. The courts punish to safeguard the community. Criminal law, from this angle, is basically a shield against actions society just doesn't approve of, whether they're inherently evil or not.
And you mentioned this connects to mala prohibita.
Right.
Acts that are wrong just because the law says so.
Beautifully exemplified there, yes. We'll get deeper into mala prohibita soon, but the core idea is punishing an act regardless of intent, purely because of its potential harm or disruption to society. Like running a stop sign, your intention doesn't matter as much as the danger it creates. That's the utilitarian perspective in action.
Okay, so laws exist, philosophies guide them. But laws also change. They get updated, replaced. How does that work? Let's talk about repeal and interpretation.
Right, the mechanics of legal change. The basic rule for repeal of penal laws is straightforward. Laws are repealed only by subsequent laws. You can't just ignore a law until it goes away, or argue that custom has overridden it. Article 7 of the new Civil Code is very clear on that. A rule stays until it's formally changed. Now, these changes, these repeals, can happen in different ways. There's absolute repeal. That's when a new law completely wipes out an old one, including its penalty, without putting something similar back in its place. This is basically decriminalization.
Whoa, decriminalization. That must have some big effects.
Huge effects. First, it completely wipes out the criminal liability for anyone who committed that act. Slate clean. Second, if there's a case pending for that now legal act, it gets dismissed. The court loses the power to even hear it. And third, if someone's already serving time for it, they get released, or the penalty is canceled. It's a really strong signal about changing societal views. But compare that to partial repeal or repeal with reenactment. This is more like editing than deleting. A new law scraps an old one, but then immediately puts back a similar penal provision, maybe with some changes. It's an amendment, really.
So the act is still considered wrong, just maybe the definition or penalty changed slightly?
Exactly. So criminal liability isn't extinguished. Pending cases, they continue. People serving sentences, they keep serving. But, and this is a crucial, but the new law must be applied retroactively if it's favorable to the accused. That's a huge protection. Otherwise, it only applies going forward. There's also general repeal, which is more of a cleanup clause in new laws, saying something like all inconsistent laws are repealed. Its effect depends on what the lawmakers intended to get rid of. And that ties perfectly into the retroactive effect of penal laws. The general rule, the default setting, is prospectivity. Laws look forward. They only apply to crimes committed after they come into effect. Like a new speed limit only applies after the sign goes up.
But we keep coming back to that exception, the benevolent rule, that powerful idea that sometimes laws can look back.
Absolutely. It's a core principle, Article 22 of the RPC. Penal laws do have a retroactive effect if and only if they favor the person accused. There are a couple of exceptions to this exception, though. It doesn't apply if the person is a habitual criminal, as defined in the code. And it doesn't apply if the new law itself explicitly says, nope, this doesn't apply retroactively to existing cases. The legislature can specifically block it, but they have to say so clearly.
That principle of favoring the accused seems central.
It really is, and it underpins the pro reo principle. You hear the Latin phrase, in dubio pro reo, when in doubt, rule for the accused. What it means in practice is that criminal laws should be interpreted strictly against the government and liberally in favor of the accused. It's like putting a thumb on the scale, always tipping towards liberty when things are unclear.
The basis for that is?
It's fundamental, the presumption of innocence. Everyone is presumed innocent until proven guilty. It's right there in the Constitution. But again, there's a limit. This pro reo principle applies only when the law is genuinely ambiguous. If the language is crystal clear, you can't twist it to favor the accused. It's about resolving doubt, not ignoring clarity. You see this applied beautifully in complex crimes under Article 48. If one act results in multiple crimes, or one crime is needed to commit another, they get treated as one complex crime. And the penalty. It's the penalty for the most serious crime involved applied at its maximum. That's usually much lighter than adding up separate penalties for each crime. That's pro reo in action. Related ideas are the lenity rule. If a law has two possible interpretations, pick the one kinder to the accused. And the equipoise rule, if the evidence is perfectly balanced, 50-50, the presumption of innocence means the accused wins. The prosecution must tip the scales beyond reasonable doubt.
Okay, let's shift gears slightly. We have the revised penal code, but there are also special laws. How do they fit together? What's a special law?
Good question. A special law basically punishes something that isn't already covered in the revised penal code. Think of specific laws about, say, illegal logging or data privacy violations or dangerous drugs. They address particular issues. And the general rule: offenses under these special laws are not governed by the provisions of the main RPC. They have their own rules, their own penalties, like a separate toolkit.
But I sense an exception coming.
You sense correctly. The exception is crucial. When the special law is silent on something important, maybe it doesn't define who counts as an accomplice or how civil liability works or rules for serving the sentence, then the RPC steps in. The RPC acts as a supplement, a backup resource, filling in those gaps. It provides default rules for things like conspiracy, degrees of participation, subsidiary penalties, ensuring there's still a consistent legal framework.
That makes sense. Now, let's explore a really fundamental distinction in criminal law. Mala in se versus mala prohibita. You touched on this earlier.
Yes, this is a core concept. Think of it as wrong in itself versus wrong because it's prohibited. Mala in se. These are acts that are inherently immoral, wrong by their very nature, regardless of what the law says. Murder, theft, assault, we instinctively know these are wrong. Even if punished by a special law, their nature is mala in se. And because of that inherent wrongness, criminal intent, mens rea, generally must be proven. The person had to know what they were doing and intend the harm, or at least be culpably negligent.
So the wrongness is obvious, and the guilty mind matters.
Exactly. Now, contrast that with mala prohibita. These acts aren't inherently evil or immoral. They're wrong only because a specific law forbids them. Think traffic rules, zoning violations, maybe some environmental regulations. Driving on the left isn't inherently bad, but it's illegal here because the law says so to maintain order. And crucially, for mala prohibita, unless the law specifically uses words like knowingly or willfully, criminal intent is often irrelevant. Just doing the prohibited act is enough to be liable.
Wow, that's a big difference. And it must affect defenses like claiming good faith.
Huge implications. For mala in se crimes, arguing you acted in good faith or lacked criminal intent can be a valid defense, unless the crime resulted from negligence or culpa. It can potentially get you off the hook. But for mala prohibita crimes, good faith is generally not a defense. The law cares about stopping the prohibited act, period. Your state of mind doesn't usually matter. Ignorance of the law isn't an excuse.
What about how far the crime progressed? Like attempted versus completed?
Another key difference. In mala in se, the law recognizes stages. Attempted, frustrated, consummated. A foiled robbery is punished differently than a successful one. The law looks at how far the criminal plan got. For mala prohibita, generally there are no attempted or frustrated stages, unless the special law itself specifically penalizes them. Usually you either commit the prohibited act or you don't. There's no attempted illegal parking.
And things that make a crime worse or less bad, aggravating and mitigating circumstances.
Considered in mala in se. Factors like premeditation or acting out of passion can affect the penalty because they speak to the offender's moral culpability, but in mala prohibita, generally not considered. The penalty provided by the special law is often applied regardless of those extra circumstances. The focus is just on the violation of the rule.
And finally, what about different roles, like who was the leader, who just helped out?
Again, mala and se distinguishes. It looks at the degree of participation. Were you a principal mastermind, an accomplice who helped, or an accessory after the fact? Different roles mean different levels of accountability. For mala prohibita, however, that distinction often vanishes. If a group violates a regulation, everyone involved might get the same penalty. The degree of participation might not matter as much as the fact that the rule was broken by all of them. It's about ensuring compliance.
Okay, we've covered the what and why of criminal law. Now let's talk about the who and where, the cardinal principles: generality, territoriality, and prospectivity.
Right, the scope of the law. Let's start with generality. Simple idea. The revised penal code applies to everyone who commits a felony within Philippine territory. Doesn't matter what your nationality is, gender, age, whatever. Once you're on Philippine soil, you play by these rules. Article 14 of the Civil Code reinforces this.
Sounds like a strong statement of equality. Everyone under the same rules.
It is. But, like many legal principles, it's not absolute. It's always subject to international law and specific treaty agreements. This leads to the exceptions to generality. These exceptions are really important. Things like treaty stipulations. A prime example is the Visiting Forces Agreement, the VFA, with the United States. That agreement sets out specific rules about who has jurisdiction, the Philippines or the U.S., when U.S. military personnel commit offenses here. It shows how international commitments can modify domestic law application. Then you have laws of preferential application. These are specific laws given priority. Think of parliamentary immunity for legislators. Section 11, Article 6 of the Constitution protects them from arrest for certain offenses while Congress is in session so they can do their jobs. Or presidential immunity. While not explicitly in the 87 Constitution like legislative immunity, court decisions have recognized it, but it's limited. Only during their term must be asserted, and generally for acts related to official duties. Also, RA 75 protects foreign diplomats. It penalizes acts that violate their immunities and privileges, ensuring they can function without interference. Ambassadors, ministers, even their registered domestic staff get certain protections from arrest or seizure of property.
Diplomatic immunity? That's a big one.
It is, and it flows into the third category, principles of public international law. For centuries, it's been accepted that sovereigns, heads of state, and diplomats aren't subject to local criminal law. It's about respecting other nations' sovereignty. The Vienna Convention lists who gets this immunity: ambassadors, ministers, etc. Interestingly, consuls used to not be exempt, but now they generally have immunity for acts done in their official functions, though maybe not for something like slander committed personally. And related to this is the warship rule. A foreign military vessel, even docked in the Philippines, is considered an extension of its home country's territory. Local laws generally don't apply on board. Same goes for foreign troops stationed here with consent, subject to specific agreements. Okay, so generality is about who the law applies to. Territoriality is about where, the basic principle. Philippine penal laws generally only have force in effect within Philippine territory. That includes our land, our internal waters, our territorial sea, and the airspace above. Our territorial sea goes out 12 nautical miles from the coastlines, following established baselines. Beyond that, there's the 200 nautical mile exclusive economic zone, or EEZ.
Right, so inside that 12-mile limit, our laws definitely apply. What about a crime on a foreign merchant ship passing through those waters?
That's where international law gets intricate. We used to follow the English rule mostly, meaning we could exercise jurisdiction unless it only affected the ship's internal affairs. But now, the globally accepted standard is the UN Convention on the Law of the Sea, UNCLOS. Since the Philippines signed it, that governs. Under UNCLOS, the flag state, the country where the ship is registered, generally has jurisdiction over crimes committed on board while passing through our territorial sea. However, the Philippines can step in and exercise jurisdiction, make arrests, investigate in specific situations, like if the crime's consequences spill over into the Philippines, or if it disturbs our peace or good order, or if the ship's captain or the flag state's diplomat asks for help, or if it's necessary to fight drug trafficking. So we have rights, but they're defined by the convention.
Okay, what about that 200-mile EZ? Is that considered Philippine territory for criminal law purposes?
That's a really important distinction. No, The EEZ is not Philippine territory. We don't have full sovereignty there. What we have under UNCLOS are sovereign rights, the right to explore, exploit, conserve, manage the natural resources like fish or oil, but not full control like over our land or 12-mile sea. Foreign ships and planes still have freedom of navigation and overflight in the EEZ, which they don't have in our territorial waters. However, we do have limited jurisdiction in the EEZ for specific things related to protecting our resource rights or enforcing customs, fiscal, immigration, or sanitation laws. But it's not general criminal jurisdiction.
Got it. So territoriality means our laws apply within our territory. But are there times when our laws reach beyond our borders? Exceptions to territoriality.
Yes, absolutely. Article 2 of the Revised Penal Code lays these out. This is called extraterritorial jurisdiction, or legal arm reaching out. Article 2 actually covers both territoriality and these exceptions, and both are still subject to treaties and those laws of preferential application we mentioned. So when does the RPC apply outside the Philippines? 5 specific cases listed in Article 2. 1. If a crime is committed aboard a Philippine ship or airship, doesn't matter where it is in the world, if it's registered here, that's the key registration, not owner's nationality, our law follows the flag. That's the flag state rule. 2. Forging or counterfeiting Philippine coins or currency notes, even if done abroad. 3. Introducing those forged or counterfeit coins, notes, or securities into the Philippines, even if they were made elsewhere. Both aim to protect our financial system. 4. When Philippine public officers or employees commit an offense abroad while exercising their official functions, like a diplomat misusing public funds overseas, holds them accountable. If they commit a crime not related to their job, though, they'd likely be tried where it happened. And 5. Crimes against our national security or the law of nations.
Let's unpack number 5. National security and law of nations.
Right. Under the protective principle, things like treason, espionage, or terrorism defined under our laws can be prosecuted here even if committed abroad. These crimes strike at the country's very existence. And under the universality principle, which also falls under paragraph 5, we can prosecute piracy committed on the high seas. Piracy is seen as a crime against all nations, hosts humani generis enemies of all humankind. So any country that catches a pirate can try them. Jurisdiction is universal for piracy. The RPC actually only lists piracy, qualified piracy, and mutiny as crimes against the law of nations subject to this universal jurisdiction.
So the reasons behind these extraterritorial rules seem pretty logical. Protect the flag, protect finances, ensure accountability, protect national security, and uphold universal norms like fighting piracy.
Exactly. They address specific needs where limiting jurisdiction strictly to our territory wouldn't be enough to protect core national interests or fulfill international obligations.
Okay, last cardinal principle. Prospectivity. We touched on this with retroactivity, but let's focus on the forward-looking nature.
Right. Prospectivity is the default. Criminal laws generally punish only acts committed on or after the date the law takes effect. They look forward. Article 366 emphasizes the code has no retroactive effect as a rule. Article 21 adds that you can't be punished by a penalty that wasn't prescribed by law before you committed the act, no changing the rules after the fact to your disadvantage.
But we keep coming back to that crucial exception. The benevolent one.
We do, because it's so important. The exception to prospectivity is retroactivity when the law favors the accused, and they aren't a habitual delinquent and the law doesn't forbid it. If a new law reduces a penalty or decriminalizes an act or defines it in a way that benefits someone who committed it earlier, that new favorable law must be applied backwards. The legislature can manage this transition explicitly, too, sometimes using a saving clause in a new law, like when the anti-terrorism law was updated. The clause ensured old decisions and pending cases under the old law remained valid.
So, to recap the exceptions to the forward-looking rule, law is favorable to the accused, law decriminalizes the act, or the law itself says it applies retroactively.
Those are the key situations where the timeline bends for justice, yes.
All right. We've covered the principles, the philosophies, the scope. Now let's talk about the absolute bedrock. The constitutional limitations on making criminal laws, the ultimate safeguards.
Absolutely essential. These are non-negotiable limits set by the Constitution itself. First, equal protection. Article 3, Section 1. No person shall be denied the equal protection of the laws. Simple, but powerful. It means the law has to treat people or things in similar situations the same way. No picking and choosing arbitrarily. Now, it doesn't mean all laws must apply identically to everyone always. Reasonable classification is allowed, but the classification has to be based on substantial distinctions, be relevant to the law's purpose, not be limited to just current conditions, and apply equally to everyone within that defined class. High standards to prevent discrimination. Second, due process. Same section, Article 3, Section 1. No person shall be deprived of life, liberty, or property without due process. And Section 14 adds, specifically for criminal cases, no one can be held to answer without due process. What is due process? Fundamentally, it's fairness. Basic fairness, the sporting idea of fair play, as some put it. It has two sides. The law itself must be fair and reasonable, substantive due process. And the procedures used to apply the law must be fair, giving the person a chance to be heard and defend themselves. Procedural due process. Fair laws. Fair trial. Third, no bill of attainder. Article 3, Section 22 explicitly forbids it. What is it? It's a law passed by the legislature that declares a specific person or group guilty of a crime and imposes punishment without any judicial trial. It's the legislature acting as judge and jury. Totally violates the separation of powers. Absolutely banned.
And right next to that in the Constitution is the ban on ex post facto laws. We talked about prospectivity. This sounds like the harmful flip side.
Exactly. Section 22 also says, no ex post facto law shall be enacted. An ex post facto law is one that looks backward and harms someone regarding a crime committed before the law existed. It specifically prohibits retroactive penal laws that are disadvantageous to the accused. So, what counts as ex post facto? A law that makes an act criminal that was innocent when done, or makes a crime more serious than it was when committed, or increases the punishment after the crime, or changes the rules of evidence to require less proof to convict than was needed at the time of the offense, or even a law that seems civil but imposes a penalty or takes away a right retroactively, or takes away a defense someone previously had, like a prior acquittal or amnesty. It's all about preventing the government from moving the goalposts unfairly after the game has been played. And finally, cruel and unusual punishment, excessive fine. Article 3, Section 19 covers this. It says excessive fines can't be imposed, and no cruel, degrading, or inhuman punishment can be inflicted. It also deals with the death penalty. It says it shall not be imposed unless Congress passes a law specifically allowing it for compelling reasons involving heinous crimes. Any death penalties already imposed when the '87 Constitution took effect were reduced to reclusion perpetua, life imprisonment. And it mandates that the use of physical or psychological punishment against prisoners or substandard, subhuman conditions in jails must be dealt with by law.
That really underscores the dignity of the person, even someone convicted of a crime.
Precisely. It reflects the principle that even those who commit terrible acts are still human beings. Punishment, yes, but not degrading or inhumane treatment. Regarding the death penalty, the Constitution didn't abolish it outright, but suspended it and set a very high bar for bringing it back. Congress must act, must define heinous crimes, and must have a compelling reason. It's not automatic, even for heinous crimes. It demands very careful consideration and restraint.
Wow. Okay, that was quite a journey through the absolute fundamentals of criminal law, from its history and philosophy right through to the rules of application and those vital constitutional limits.
It really covers a lot of ground, doesn't it? And if you connect all these pieces, you really start to appreciate the sheer amount of thought, the debates, the practical needs that have gone into shaping how we deal with crime and justice. You can see why these specific rules, generality, territoriality, retroactivity, pro reo, are so critical for trying to maintain order while also ensuring fairness. It's a constant balancing act.
Yeah, balancing free will versus social factors, balancing the need for clear rules with the need for fairness when rules change, balancing national law with international norms.
Exactly. And seeing how concepts like mala in se versus mala prohibita change how we approach intent and defenses, and how territoriality draws lines on the map, but then exceptions have to be made for ships, diplomats, national security, and all of it anchored by those powerful constitutional protections, due process, equal protection, no ex post facto laws. Those are the ultimate safety nets.
So for you listening, what's the takeaway? Hopefully you now have a much more solid foundation for understanding the legal framework around us. Not just memorizing rules, but grasping the why behind them. That helps you engage with legal news, policy debates, everything with more insight.
And it leaves us with a really important question to think about, especially today. In our super interconnected world, How do we strike the right balance between a nation's undeniable right to make and enforce its own laws within its borders and the growing need to respect international norms, human dignity, and the complexities that arise when laws and people cross borders more easily than ever before? Where does that balance truly lie?
Something definitely worth pondering. Thank you so much for joining us on this deep dive into criminal law. Keep that curiosity sharp, and we'll catch you on the next exploration.